Hello, my name is Van Smith, managing partner here at Smith Strong, and today I'd like to talk to you about preparing for your first divorce consultation here at our firm. It's a call that I never like hearing needs to happen, but happens every week in this office. But this past week, I had a call that I wanted to share with you the basic particulars. So if you're out there also struggling, you too can prepare properly for your first consultation for your divorce, custody, child support, and spousal support matter. A woman called our office and said, Van, I have a friend that works with me that I'm very close with. And 3 women came to her and approached her and said, we've all had relationships with your husband outside of marriage, and we wanted you to know this is going on, and we wanted to confess this to you. She then confronts her husband, change or leave, and he left. Add to this that they have 1 child, and in 4 short weeks, she will be expecting their 2nd child. So obviously the emotions of the call were high. And she asked me very simply, how do I prepare for my meeting with your firm and an attorney at your firm for this divorce matter? And so first, we don't put anyone on the express lane for a transition out of marriage. That has to be done thoughtfully, carefully, and slowly. But there are times when we do surround the person that calls us, provide them an emotional support, and then give them a framework for how to transition. So there's a family left standing, even if no marriage. And so when you're organizing yourself and your family's finances to meet with an attorney for the first time, there are some basic things that you should do. For instance, when you call our office, we will be giving you an intake packet to complete and help guide you. So don't feel like you have to take notes during this video to get it all down and make it perfect. We will make sure you don't mess this up. But here are a few things to keep in mind. Number 1, a chronology of events that lead you to the moment in the transition you're in. If there are incidents, if there's cause, and not just we've grown apart over the last 7 or 10 years, but there are actual incidents that have led to the separation and ultimately possibly the divorce, we need to know about those with as clear a chronology as possible. Second, biographical data. The names of you, your husband, your children, your social security numbers, your dates of birth. If there are witnesses to these incidents, their names, their information, if possibly known. Moving on to the assets. We need to know if you have a home, what the mortgage balance is. Is it paid for? Do you have other investment properties? Where are they located? The addresses? Are there mortgages? What is the rough and approximate balance? Do you have mortgage statements that you could bring to the appointment so we understand what is the equity position in each of these properties? Second, bank accounts. We need to see a copy of a statement of each account from the time of separation. So if you all have been separated for 2, 3, 4 years, we need to see a statement so that approximates the time when you separated and a current statement if possible. If that's too hard to get, do not worry, we can get it later. But if you have time to prepare a statement of each bank account that you own, your spouse owns, and that you have jointly. If you have your own private businesses, statements related to those businesses, investment properties would also be appreciated. A statement at or around the time of separation and the present month, if possible. Third, non-retirement investment accounts. So this would be stocks and bond accounts that are not in a retirement account. So they're not in a 401k, they are not in an IRA. They are just individual stocks or brokerage accounts that you invest additional monies in. Yours, theirs, or jointly. Fourth, retirement accounts. These are the qualified retirement accounts. These could be pensions, 401ks, IRAs, Roth IRAs, 403bs. If you're a teacher, the Virginia Retirement System, VRS pension, or deferred balances of deferred thrift savings plans, if you're the TSPs, if you're a federal government worker. But a statement of approximating the time of separation and a current statement. If they're one and the same, then that we just separated, then bring just the current statement. Fifth and finally, life insurance. The declaration page or DEC page of each life insurance statement you have in your life, their life, and any child's life. Some of you also have declaration pages of previous spouses. Please bring those too. We need an accurate representation of the assets, and the best way to see that is through these statements. Next, liabilities or debts. Please bring one statement of each credit card bill. Even if you zero it out and pay it off every month, a representative statement of the nearest month of each credit card in your name, their name, or jointly will be appreciated. Next, loans, mortgages, home equity lines of credit. What are the current balances? Best shown through those statements. As you print these off or save these to a file that you put on a thumb drive and bring to the appointment, either way. But if you do print them off, it would be helpful to label them with a Post-it note in the top right corner, labeling what it is, your account, their account, bank, or retirement account. As you hand them to the attorney, just makes things go smoother. If you don't have a printer, it's not feasible to do that, don't worry about it. You can always email them to us. You can screenshot them with your phone. We'll take whatever we can get. Next, we want to understand, if you have children, what is the current custody visitation schedule currently? Not what you want, but what you have right now. Next, we need to understand what you want. We also want to understand what they want. It may not be what you want, but it's helpful to understand what they want as far as child support, spousal support, or alimony, child custody visitation. And then if you have a sense of what you would like to divide, how you would like to divide the property, what their goals are for property division, think through that. Now, word of caution. If you have not disclosed to your spouse that you're considering this, please do not, in anticipation of our first meeting, do that. Please hold off on disclosure, unless it's already broadly known, until you meet with the attorney first. There may be additional documents. There may be a poor reaction that blows the situation up and out of proportion that would have been helpful to hold back and make sure we have all of our ducks in a row before this alarming event of notice and disclosure occurs. That's not always true in every relationship. Maybe you're very comfortable speaking with your spouse and you all have already kind of laid it all out and went to dinner and laid it all out, and now you just need an attorney to draw up the paperwork. Great. But every relationship's a little different. If yours is more volatile, less communicative, hold off on disclosure, meet with us first. If you're very open, warm, friendly, and everyone's on the same page, by all means, share it, but please appreciate your relationship and be honest with their likely reaction. I will tell you, I have been in meetings where the person has disclosed it before meeting with the attorney, and they're meeting with me saying, Van, he or she has drained all of the bank accounts. They've changed the locks on the doors. They've taken the kids to the mothers. There are all sorts of terrible situations that can develop, which impede and delay our ability to process a case by months and sometimes even years if we don't plan in those early stages appropriately for your relationship and the reaction your spouse is likely to have. I've written a book on all of this, and I go through it in greater detail. You can receive a free copy of that book. It will be electronically sent right to your smartphone. We can also mail you a hard copy for free. You can claim that book at smithstrongbook.com. That's smithstrongbook.com. If you're unable to find that URL, just go to our main website and click on the free divorce book icon, and we'll make sure you receive a copy. If you're at all confused by that, simply give us a call, 804-325-1245. We are in courts within a 2-hour radius all around Richmond and serving divorce and custody and support clients all over the Commonwealth of Virginia every week in this office. If you are facing this transition and you're sure it must occur, come meet with us, and it's our delight to serve you and walk alongside you through this journey. Thank you.